Now stand the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, and please be seated. Good morning. Welcome to the Appeals Court. I'm Justice Peter Sachs. To my right, your left is Justice Suk-Young Shin. To my left, your right is Justice Rachel Hirschfang. Will be your panel for all 6 cases today. If you have been to the Appeals Court before, you know you have 15 minutes. The light is green when you start. It turns yellow when you have a minute and a half left. Turns red when you're done. You can finish your sentence. If you're in the middle of a question, you can finish that. We have read your briefs. We're familiar with the record, the facts, the procedural background, so we'd encourage you to jump right into your argument because 15 minutes goes by pretty fast. So with that, I will call the first case, 24P94, 266 River Street Development, LLC versus Martin. And one more thing, if you see us looking down at our iPads here, we're not checking the Facebook or the news. We're looking at the record materials. We've got your brief and the record on our iPad, so that's what we're doing. All right.
Thank you, Your Honor. Good morning. May it please the Court. First arguments that I would like to address at this particular point are the accelerator clause issue, the oral extension of the closing.
And you're Mr. McMillan, correct?
I am, Your Honor.
For the Martins.
Yeah, thank you. In like that. I'm trying to use my time quickly. In any event, so with respect to one other, which is the failure of the plaintiffs to provide material facts and documents with respect to the request for the issuance of the lis pendens. Dealing first with the accelerator clause and the oral extension, neither of those two issues were either raised or briefed at the time of the lower court hearing, so I don't believe that it's properly before this court on appeal and that they should not be addressed, and that should deal with the issue with respect to those two.
You're referring to the issues, the arguments that it was a bilateral contract?
Yes, Your Honor.
And then the second one, are you referring to the allegation, the complaint that there was some sort of oral agreement to extend until July 22nd?
I don't believe that it was in the complaint itself. I think it was made as an argument that, well, not July 22nd, July 31st, 2023.
So what's the issue that you're saying is not before us?
I don't think the issue of the oral extension is.
Okay, so there is an allegation in the complaint about it. So is that what you're referring to?
Well, there's an allegation of of a date of July 31st, 2023. The problem is it's quite confusing. Since there was no written exercise of the option itself, which was in a particular format, we're not sure what the deadlines were. Even if it was a 6-month extension from the date of July 31st, 2023.
There was an allegation in the complaint, paragraph 29, that the 6-month extension caused the option period termination date to be July 31. Whether that's a correct interpretation of the contract, I'm not sure. And there's also an allegation that there was a verbal agreement to extend the closing date to July 22nd. That's paragraph 45.
Well, which we'll get to that in just a moment, though. The allegations, though, unfortunately, at the time that we argued in front of the trial court judge, they didn't raise the issue of the oral agreement at that time.
So you're saying even though it was part of the complaint, it wasn't argued, and therefore it's not before us?
Well, there's no supporting facts other than that bare allegation contained.
Well, it's a verified complaint. It was denied in the answer, but it's, I mean, does that make it frivolous, or does it mean that that argument has no reasonable basis in fact? Obviously, there's a dispute, but.
Well, I think we're going to come to our argument is that it has no bearing ultimately because there's no oral agreement which is permitted by the statute of frauds.
Well, the judge said that the statute of frauds had an exception where there had been reasonable reliance on some oral representation. And what's your reaction to that? And in particular, I didn't see you arguing that there were no facts to support the reliance, at least until your reply brief in this court.
I think that all the issues that were raised in the reply brief are germane to the fact that there was no reliance on any extension that would have occurred orally back in July of 2023 because of the...
Did you argue that to the judge below?
Well, I believe we did.
On the motion to reconsider, I
Yes.
suppose, would have been the place to do it, because in his decision, he said there's this exception to the statute of frauds. And so did you come back and say, but it doesn't apply here?
We did. And I think one of the problems that we have is that since there was no written exercise of the option, which had very specific language, and it was language that was put together by the plaintiffs, not by the defendants, that would have given us the timetable. So, for instance, in the extension which took place, there should have been a P&S signed within 3 days. And the option itself actually provided for I think it was a tendering of the quitclaim deed within 30 days. And since we don't know what the date of the exercise of the option was, whether it was by waiver or not, we don't know when the deed was actually supposed to be tendered. Because not the January 31st, but the July 31st date, which was the end of the 6-month extension, presumably went to the exercise of the option, even though the options notice provisions required that it be exercised by June 15th of 2023.
So can you point to us where you asked the judge to not rely on this exception to the statute of frauds because there were no facts to show reliance?
I will have my co-counsel look to see if she can find that in the transcript right now, but I can't off the top of my head.
Okay, so I'm a little bit confused about what we're talking about here. So the extension extended the date to exercise the option until June 15th.
Yes.
And the judge found, seems by implication, that extension then extended the termination date of the agreement to July 31st. Are you disputing that? Because the original agreement said exercise the option by December 15th. The term of the agreement is until January 31st. And so the judge said, well, so if you're extending it by 6 months, the termination date of the agreement is now July 31st. Is that in dispute here?
Well, I don't think the termination date per se is in dispute.
Okay.
However, the difficulty that we have in comprehending what was put together is I don't know why there was an additional 45 days since notice had to be given on December 15th in the first instance and June 15th in the second instance. So if you don't exercise it by June 15th, it doesn't extend automatically the time to exercise it to July 31st.
I understand. I'm just asking, when you're talking about an alleged oral agreement to extend, what are we talking about? To extend the option? To extend the date to exercise the option?
I believe that the extension, as referred to by the plaintiffs, wasn't for the exercise of the option. It was for the
Closing date, right? But
Right.
why does that matter if you don't dispute that the closing date was extended to July 31st?
Well, I do dispute that necessarily the closing date was July 31st, because the way the option is put together, it says within 30 days of the tender or receipt of the notice. But we have no way of calculating that.
What's within 30 days?
So the deed had to be conveyed within 30 days of the exercise of the notice. So if you go to the original option to purchase, and it's also, I believe, contained in the addendum, not the addendum, but the second extension, it says right in the notice provisions that the deed is supposed to be tendered within, the P&S signed within 3 days.
It also says the term is until January 31st, unless sooner terminated. And then later it says the grantee may exercise the option to purchase at any time during the term of this agreement. What does that mean?
I don't know, I didn't
I mean,
draft the
doesn't
one.
that conflict with the provision saying that the option has to be exercised by December 15th? Grantee may exercise the option to purchase at any time during the term of this agreement. What is the term of this agreement?
Again, the paperwork was put together by the plaintiffs, not the defendants, and I think that has to be construed against them because it's a nonsensical deadline since the exercise had to be 45 days earlier. So it had to be on or before initially December 15th of 2022, and then in the second instance by June 15th of 2023. It didn't extend the time, at least the way we read that contract, and as I say, since the plaintiffs drew it, it should be construed against them.
But is that an unreasonable interpretation of the contract, or is it an interpretation that's without basis in law, such that your special motion to dismiss should have been granted? It seems arguable.
Yeah,
I mean, there are a lot of ambiguities in this agreement. It seems arguable.
I agree, and Your Honor hit the nail on the head. We do think that is a term, because of its ambiguity, makes the special motion to dismiss ripe for allowance, because it's a factual issue and it's a material issue, and that's an issue of law.
Is there even any evidence in the record that this option agreement was drafted by 266 River Street?
There is evidence that at the time of the oral argument in the Superior Court, I represented that both the the P&S, the extension, and the underlying option was drafted by plaintiffs. And I would refer the court to pages 142 in the record appendix, which should be the transcripts, and page 145.
But that's not evidence, that's a representation of counsel.
Unrefuted by opposing counsel. Worst case scenario, it's an unresolved fact, and I've represented as counsel for the defendants that they did not, in fact, draw the option, the extension, or the purchase and sale agreement, which was to be attached to the option notice. And I don't think that in any of the arguments that were contained in our brief did the plaintiffs refute that. Consequently, we believe that can be taken as an accepted statement of fact. And as we know, it's all the evidence that was before the trial court was documentary evidence. As such, this court is allowed to make whatever inferences that they choose to with respect to the implications on both the Liz Pendens as well as the special motion to dismiss.
So even when the special motion to dismiss has been denied, there's nothing stopping you from filing a 12b6 motion, is there? I mean, if hypothetically we were to affirm here, can you still go back and file a 12b6 or a motion for judgment on the pleadings, or perhaps a motion for summary judgment?
We can. We chose to exercise a quicker route because we were hoping to cut it out at the beginning as opposed to the end, because that would entail more discovery, filing of subsequent pleadings, particularly if it's a special motion for judgment. And in fact, under 184, Section 15C, I think it is, this is sort of the type of ability that the appellate court has in reviewing an order issued by the trial court to take a look at everything that has been filed, and it's sort of akin to a motion for summary judgment. But I mean, obviously, depending on what happens here in this court with respect to the Liz Pendens, because obviously in the short term, the property is tied up. The defendants can't do anything with the property in the interim while this is still ongoing. So we were hoping to get up here in front of the appeals court and get an interlocutory order as a result of it. And that has been relatively quick at this point. We'd still be in discovery phase if we sought to chose to go through. I don't think
Can
we
you
had
proceed on two tracks simultaneously? I mean, can you push ahead with the matter in Superior Court even while this appeal is pending?
I suppose we could have, but again, I don't know that the client would be willing to incur that type of financial cost, because it's, especially with a motion for summary judgment. So I think we want a definitive answer once before we do that with respect to this court's opinion on whether the Liz Pendens should have been issued. So the second argument, which I was talking about, the oral extension of the time to close, again, because there was no notice that was sent out and no timing determined with respect to when a actual closing should have taken or could have been taking place. All the case law seems to indicate, along with the statute of frauds, that that's a material term that should have been included, should have been done in writing, and it wasn't done in writing. There's no correspondence that would have qualified under the statute of frauds that indicated that they were looking to do.
What's your answer to the judge's conclusion that there was enough, essentially that there was a waiver, because the parties kept on dealing with each other after all of these deadlines passed, including an email from your client, I believe, on June 18th or so, saying, what's up with the closing? When do you think your clients might be able to close?
Well, June 14th, the day before the exercise of the option was due to expire, they did send an email to the plaintiffs. And again,
But they also sent one after June 15th.
They did.
On June 19th. Do you know when we might be able to close? Which
But-
sounds to me like we're still treating this as a live transaction or a live option.
So well, if there was an absolute, unequivocal, decisive claim that there was an extension at that particular point in time, but none of the correspondence that came back from the plaintiff's counsel indicated that there was a date certain. And even the, as I say before, the June 31st date was to the exercise of the option, not the option turn date. So had they done it correctly, sent out the notice that was required by the option, it would have triggered the 30 days, 3 days to sign the PNS and 3 days to act on it.
Okay.
30 days, rather.
All right, thank you very much for your
Thank you, Your
argument. We'll hear from the appellee. Attorney Entner.
Good morning, Justice Shin, Justice Sachs, and Justice Hirschfang. May it please the court. My name is John Entner. I am here on behalf of the plaintiff appellee 266 River Street Redevelopment, LLC. We believe that this court should affirm the findings of the lower court, the trial court, when they denied the special motion to dismiss and denied the motion for reconsideration. We believe that the trial court and Judge Lang issued a thorough, thoughtful decision that carefully examined the facts as pled and properly applied the law as it applies to the standard for a special motion to dismiss, as it applies to waiver, and as it applies to the pleading requirements for a verified complaint and for a motion for a lis pendens to begin with. We believe that the appellants are essentially arguing that the weight and the sufficiency of the evidence and the pleadings weighs in their favor. And we think that that's clear from their arguments that the statements don't rise to this level of creating a waiver issue, or they believe that the arguments don't quite measure up to what would eventually grant us relief. And I would remind the court, and I believe the court has asked questions along this line, that the standard is actually devoid of reasonable basis in law and an arguable reasonable basis in fact and an arguable basis in law. And I think that Judge Lang in his decision accurately found that there is an arguable basis here, that where there may be ambiguities regarding when things happened or who was doing what or who was saying what and at what time, those create issues of material fact that are not before him to find one way or another and not ripe for summary judgment, but should move the case forward past the pleading stage into the discovery stage.
Can you tell us by what date, on what date, or by what date did you exercise the option?
The defendant appellants are correct that our clients did not issue a written exercise of the option as required in the agreement. We agree with that. It's our position that at some point a conversation between these parties, there was a waiver, there was a notice of that option. We think that the behavior of the parties makes it clear that they were moving towards a closing, that it wasn't simply a waiver.
By what time?
I'm unable to say at this time. I think that's a question that is going to have to come out in discovery. My clients are uncertain as to what
because
time
the
that may have
dates, the subsequent dates are all, for the PSA and the closing, are calculated from the exercise of the option, right? And if you didn't exercise the option, then you forfeit your $200,000.
Correct. I think that it's clear from the behavior of the parties that there must have been an exercise of the option, or an understanding between the parties that there was an exercise of the option, based largely on the emails that Your Honor has already referenced, and specifically who those emails were coming from and the language that they used. Those emails weren't coming from the appellant defendants, they were coming from their real estate attorney. The real estate attorney specifically referred to not an extension of this thing or, hey, are we moving forward? They specifically referenced a closing. They referenced a closing in emails earlier in June when they were emailing back and forth with lenders counsel as well, where they specifically asked, are we on for closing tomorrow? Where are we for closing? I would find it hard to believe that they're arguing that their own real estate attorney was so poor at her job that she was confusing the exercise of an option with an actual closing.
Well, I mean, I don't think you need to go that far, right? We've all bought and sold property, and we all know that there are tactics and techniques that can be used to try to kind of move a deal along when it looks like it might be stalling. So I don't know that, you know, their real estate attorney seemed to think there was going to be a closing is an effective substitute for the exercise of an option. I know you've cited the Sourcing Unlimited case. Is that your best precedent for the notion that there is now so much flexibility in Massachusetts law that you don't even need to exercise an option when the option has distinct terms that you need to follow in order to exercise it?
I think you still need to exercise an option. I'm not making the argument that you don't need to exercising it. What I think I am reading in Sourcing Unlimited is this idea that exercising an option is broader than exactly what the parties agreed to, and sort of a recognition that a lot of these deals are being kind of created and largely carried out without the assistance of counsel, perhaps, until it gets to the final stage where there is a closing or there are environmental concerns or title concerns. And I think that reflects the behavior of the parties in this case. I don't believe there was counsel at the beginning when they were drafting this option agreement. I don't believe there was counsel for most of the behavior of the parties in the in-between. These are two parties that are going along to get along, working on a deal, having a lot of conversations in person or by phone, handshaking a lot of things that otherwise, as attorneys, we would prefer to put into writing. And I think Sourcing Unlimited recognizes that and recognizes this idea that perhaps the exercise of option between unsophisticated parties or even between parties that aren't counsel is enough to, that there are forms of notice and agreement that can be brought out at trial that don't necessarily have to be written exercises sent with certified mail and held to that high standard.
So the issue in Sourcing Unlimited was not that there had been a failure to exercise the option, but that it had been done by email, which was explicitly not allowed in the terms of the contract, right? That it had to be done in writing, and that the party who was attempting to exercise the option in Sourcing Unlimited was told at least twice and maybe 3 times, I can't remember, like, hey, you have to do this in writing, this isn't enough, and yet kept reiterating. So to put my question in English, the issue in Sourcing Unlimited was not the absence of notice. It was the means by which the notice was delivered. And the court held, you know, in these circumstances where it's clear that everybody understood what was going on, the means is not enough to throw this out. That feels very different to me from what's going on here. Is that your best precedent?
I think that would have to be some of my best precedent. I haven't discovered any other case law, I think, that kind of gets to the idea of whether an oral exercise of an option or an oral agreement between the parties would substitute for a written exercise. And I think my brother counsel highlights that a little bit in his reply as well, is that the appeals court in Sourcing Unlimited didn't quite reach as far as to talk about what would happen if it was an oral exercise of an option, but they did seem to imply pretty heavily that this court would look unfavorably on that. I think in a modern world where parties are talking a lot more frequently, or where there are alternative forms of writing like text or more informal forms of writing, such as online messaging applications, I think that there is reasonable basis for this court to say, from the behavior of these parties, at least at this stage for a special motion to dismiss, where the standard is devoid of reasonable basis or arguable basis, I think this court can say, there's enough here from the behavior, especially of the defendants and the communications from their counsel, to say that this there may have been a notice that everybody was kind of operating under, or an agreement that everybody was operating under, or at the very least a waiver. And I think that's what Judge Lang is getting at, is at this point, with the facts as pled, read in the light most favorable to the pleading party, where the standard is devoid, it's just not devoid. There's enough here to move this on to the next stage. And I don't think it eliminates the defendant's ability to come back later for a summary judgment, as Justice Sachs was referencing earlier. I think where this is a motion to dismiss that takes in facts and documents outside of the pleadings, it's more broadly encompassing than a 12b6 motion, so I'm not sure whether they would be able to go back.
So a waiver has to be shown by clear, decisive, and unequivocal conduct, and would you agree that's not shown in this record?
No, I disagree. I think Judge Lang got it right that there is clear and unequivocal conduct after the deadline for the option.
Just the email saying what's going on, essentially?
Well, it's emails from a lawyer asking about, are we closing? My clients don't want to sign this deed if we're not closing tomorrow. And I think where the conduct is limited in scope, it's 1 or 2 emails, it's not very much communication. The content of those communications, I think, is important, especially where it's coming from.
So the judge relied on prior actions by Paul Merton cooperating with the approval process, preparing to move his business out. Are you relying on that as well? Because it's hard to see how that would be a waiver, given that the agreement itself required him to cooperate.
The option agreement did require him to cooperate to a certain extent. There are some specific benchmarks that Judge Lang references that I think are found in the option agreement as well that indicate post-notice, specifically the environmental studies. Judge Lang references that there was a Phase 1 environmental study and they were making arrangements mutually for Phase 2 environmental study. The option agreement says the Phase 2 environmental study doesn't come up until after the option agreement has been exercised. So these were parties that were taking steps in the option agreement itself that are post-exercise, including preparing for closing, clearing potential title issues, the Phase 2 environmental study. Whether the exact details of what those environmental studies contain or require or what they exactly were planning are slightly outside of the pleadings. They weren't argued or developed too much down at the trial court, but Judge Lang, from the documents available to him and from the arguments of counsel, said there's enough here. This isn't devoid of a reasonable basis in fact. There's fact here that is subject to further discovery and a finding from a trier of fact.
So in his footnote regarding the equitable qualification to the statute of frauds, he refers to the sort of reliance notion that if you proceed and change your position in reliance on the other party's continuing assent, then the oral agreement may be enforceable, notwithstanding the statute of frauds. What change of position was there, for example, after June 15th?
After June 15th, I'm not sure there was much of a change of position, so much as there was the parties continuing to be in communication with one another and working towards a closing. There is that email from the Real Estate Council on June 19th. There is the allegation, as Your Honor pointed out in paragraph 40 of our complaint, that there was an oral extension to a closing date to July 22nd. Right,
but the question is that oral extension valid? So what was done in reliance on that oral extension?
The parties were still, the plaintiffs were still working on securing the necessary funding and finalizing everything they needed to on their end for the closing, and they were kind of caught unawares by this unilateral. Right. They were working on it.
But is there anything in the record showing a change of position in reliance on the claimed oral extension?
Well, I think the claim of the oral extension is more argued to say that them terminating on the 14th and saying no closing going forward was a unilateral change of their previously stated position of the defendant.
You mean July 14th?
Yes, July 14th, I apologize. Judge Lang sort of sidesteps that argument a little bit in his decision where he says, well, the term of the option agreement, the extended option agreement, is until July 31st. So the idea that there's this oral extension is sort of moot because there is still this window of time where the parties are looking to close. Even if, hearing my brother's arguments this morning, even if there was a 3-day period to do a PNS and then a 30-day period to do a closing from the time of the giving of the notice, or I suppose from the date of the notice, June 15th, the expiration date, that still brings us within that time frame. They're still canceling the...
I'm a little bit still unclear about how the statute of frauds relates to this case. Are you claiming that there was an oral agreement to extend the date to exercise the option, or there was just an oral agreement to extend the date of the closing?
Just the date of closing.
Okay.
We're not making the argument that they orally extended the date of the notice.
You're saying that was waiver by conduct or something like that?
Correct, or pre-existing
So why are we talking about the statute of frauds when the judge said the extension agreement, by implication essentially because it doesn't say it, extended the termination date until July 31st?
The statute of frauds is the third leg of the standard for a special motion to dismiss whether the complaint, a verified complaint, has any reasonable basis in fact, arguable basis in law, or subject to an affirmative defense.
I understand legally, but as a factual matter, what is it that we're saying should have been in writing but was not?
I don't think I don't think the statute of frauds necessarily applies. I think that all the material terms of the agreement between the parties was in the option agreement sufficient to make that a binding agreement for the sale of property.
So do you agree with the judge's conclusion that the extension, 6-month extension, extended the term of the agreement to July 31st?
Yes.
Okay. What do you make of the provision in the original agreement that says the grantee may exercise the option any time during the term of this agreement?
I think it's evidence that this was an agreement that was put together without assistance of counsel between two parties who wanted to make a deal happen. I think also the provision that I cite that my brother counsel briefly addresses, which is the acceleration clause, is more evidence of that. I think it's a largely nonsensical provision where you're talking about an option agreement, but it was something that the parties negotiated for whatever reason they put it in. And I believe that's my time. If the court has any further questions, I'm happy to answer.
All right. Thank you. Thank you both for your arguments. Our next case will be 23P 1395. This is, as you know, a partially impounded case, and we'd urge you to be cautious about revealing personal information in your argument.
Yes, Your Honor.
There's also, by the way, an issue with personally identifiable information in the record appendix and whether that should have been redacted. So we may be issuing an order on that.
Yes, can I address that
Sure.
prior to my argument?
Sure.
Just that this case was attempted to be impounded in the Superior Court. However, that was withdrawn, which is the only reason that it was indicated in this appeal that it was impounded in any way. But
Okay.
I will keep that in mind.
All right. Thank you.
May it please the court, Leah Duffield for the appellant. This appeal was submitted due to 2 errors by the trial court judge leading to the dismissal of the plaintiff's complaint. First, that the trial court judge erred in failing to recognize and properly apply the discovery rule exception to the 3-year statute of limitations for personal injury cases. The 3-year statute of limitation period commences after the cause of action accrues under Massachusetts General Law 260, Section 2A. However, that statute doesn't define what the term accrues means. It's understood to mean when the plaintiff was injured, but there are exceptions to that, meaning the discovery rule, extending when the statute of limitations starts when the plaintiff reasonably should have known about the injuries and the cause of those injuries.
So that leads to one of my questions for you, which is this complaint is very sparse. And I did not see any allegations in it about when your client first recognized the symptoms that led to her surgery and that were linked in either February or April of 2020 to the rape. Is there anything in the record that talks about when she first started experiencing the gastrointestinal issues as opposed to the other, I'll say, sort of more expected medical effects?
In the record submitted to both the Superior Court and the record that Your Honors have before you, there's nothing submitted because those medical records were not going to be disclosed until the discovery phase. But yes, within her medical records, there are indications pointing to exactly when she started to experience those issues, which was in 2017. So from 2017 to 2019, she was experiencing gastrointestinal issues, which led her to seek more medical treatment and eventually led to a diagnosis in February 2020. So February 27th, 2020 was the first time that she was diagnosed with outlet dysfunction. Apologies. Was the first time that one of her providers connected the sexual trauma to her gastrointestinal issues.
And I saw that in the complaint. That's paragraphs 10 and 11 of
Yes,
the
Your Honor.
complaint. But the thing that you've just mentioned about 2017 to 2019 is nowhere in the record that was before the judge who ruled on the motion to dismiss.
Correct, Your Honor. The second issue that I wanted to address was that this...
So, I'm sorry, you think there's a issue of fact when she was experiencing issues within 3 years of the alleged assault, which was in 2015, right? And you're saying it's on the record, but you do say in your opposition she was experiencing gastrointestinal issues for years, right?
Yes.
And you're saying there is a factual issue whether a reasonable person should have known at that time whether she was harmed by the assault or whether it was caused by the assault, or both?
So both. There's, in a few of the cases cited in my brief, there's a two-pronged test, whether a reasonable person should know of their injuries, and then whether a reasonable person should know of the cause of their injuries.
Don't you know about your injury if you're suffering symptoms?
Well, I think that depends, and all of these cases are very fact-specific. So in this present case, yes, Ms. Clear, the victim was raped, and then she treated and knew about typical rape injuries. So indicated in her rape kit was bleeding, abrasions to her vagina and cervix. So she treated for those because her medical providers told her to treat for those. So then 2 years later, experiencing constipation, abdominal issues, dietary issues and vitamin deficiencies, that would not lead a reasonable person back to the 2015 rape.
But what do you do with the language in Bowen versus Eli Lilly that says the plaintiff need not know the full extent of the injury before the statute starts to run?
I would say, yes, that's cited in Bowen, and it's also cited in Coe, but this wasn't the full extent of the injuries. These, I would argue, are entirely different injuries. She treated for those vaginal abrasions, the cervical issues.
How does one draw that line, and what case draws that line? And these were injuries directly attributable to the rape.
So no case draws that specific line. However, some of the cases cited, such as Doe v. Cretan and Riley v. Presnell, they're about psychotherapy issues. So the plaintiffs knew that they were suffering from some sort of mental health issue. But until their medical provider connected the past sexual abuse in those cases directly to their current symptoms, that's when the statute of limitations began to run.
But that link in those cases, correct me if I'm wrong, was important to know not only that there was an injury, but who caused it. Seems to me that here there was knowledge immediately after the rape, both that there had been an injury and who caused it. So the fact that other injuries developed later doesn't mean that the statute didn't start to run at the time of the original.
I think those cases can be distinguished from this present case because of the nuanced facts of this case. It's not just an extension of the vaginal trauma, the initial sexual trauma. These are internal, non-obvious symptoms. So it's not like a emotional distress issue in these other cases that led to further mental health issues, or, for instance, a scratch on your finger, which eventually led to needing stitches or an infection of some sort. This is a completely different issue to a completely different part of the body. And so there's no way for a reasonable person to say that later on these internal injuries were directly correlated to this sexual trauma 5 years earlier. More on that.
You're saying, I mean, you're arguing it's a latent injury that was unknowable until she got medical treatment and a diagnosis. But if somebody is experiencing symptoms, can they just wait for an indeterminate amount of time before they seek medical treatment? Isn't there some point at which they should know that they've been harmed?
Yes, of course, Your Honor. And most of the cases cite the exact same terminology, but to paraphrase, it's basically the plaintiff can't just stick their head in the sand and ignore their symptoms. They have to actively seek medical treatment from their providers. And she did. She sought medical treatment 8 days after the rape, received a rape kit, and continued treating with her medical doctors. And she continued seeking treatment up until that 2017 date when she started to experience these gastrointestinal issues, regular checkups. But until her medical provider made that connection, there's no reasonable way that a person could make that connection. And in a few of the
You're saying she was getting treatment between 2017 and 2020?
As regular medical checkups, and then further once she started to experience these gastrointestinal issues.
The problem I have is that that's just not in the record. There's nothing in your complaint about what she did between going to get the sexual assault examination and then being diagnosed in either February or April of 2020, which is in the complaint a combination diagnosis and attribution of cause to the rape, right? So it's very difficult to try to grasp the reasonable person part of the analysis that we need to do when there's nothing in the record that explains what she was feeling, what doctors were telling her, how often she was going, when she first heard that there might have been a connection. I mean, in the DES case, the Eli Lilly case, her doctor says, listen, this is something that we're starting to see in women whose mothers took DES during pregnancy, and then she goes, she starts kind of following it. We don't have that moment in front of us in your case.
So to that, Your Honor, I would say that this case was at its infancy stages. No discovery was exchanged in that DES case and the Co case that the trial court judge relied solely on. They were well into the discovery phase. So in the DES case, it was shown that the plaintiff had those communications with her medical providers saying, did your mother take this drug that caused this cancer?
Decided on summary judgment, right?
I'm sorry?
Decided on summary judgment.
Yes,
right?
Your Honor.
But in a motion to dismiss, we look at the well-pleaded allegations in the complaint, viewing them in the light most favorable to the plaintiff.
Yes, Your Honor.
And so is what you're saying that if the well-pleaded allegations in the complaint aren't everything and don't allow us to apply the test, the second part of this test about the reasonable person, you should get to keep going in order to prove that there's more out there because it's a motion to dismiss and you should survive?
Well, yes, Your Honor. I'm saying that there's enough substance in the complaint to allow a cause of relief. And so even though it doesn't have all of the facts and all of the documents that would be given in the discovery phase, and then allow for the defendant to file a motion for summary judgment after the fact if new facts were found that there was no question, I'm saying there's enough in the complaint to allow this to move forward on the merits, because she showed that she was injured in 2015 and she did not discover her injuries, the gastrointestinal injuries, until at the earliest February 27th, 2020.
But that's not right, because you told us earlier that she discovered the gastrointestinal injuries, this is not in the record, starting in 2017. So what you're really saying is she did not discover until 2020 that there could be a causal connection between the rape and the gastrointestinal issues.
Correct.
Which is what leads me to ask about the second part of the test and not the first part, because you're not, when discovery comes in, presumably, you're not going to be saved by she didn't know, right? You need to be saved by she reasonably wouldn't have known. And that's what I'm looking for and not finding in the complaint.
Right, Your Honor. So I think with, again, the facts of this case are so specific that, yes, she knew she was experiencing gastrointestinal injuries. She did not discover, I guess her diagnosis would have been the better way to word what I was saying. She didn't discover her diagnosis, which was a pelvic floor dysfunction, and that's what led to the outlet dysfunction diagnosis. So she did not discover that as the injury. She knew she had gastrointestinal injuries, which led her to continue her medical treatment, which is basically a requirement under these cases, that you can't just throw your hands up and say, I'm experiencing these issues and I'll think about it later. She actively went out and sought treatment, trying to get some sort of diagnosis, and then try a connection back to the 2015 rape.
There was no answer filed in this case, right?
Correct.
So we're just looking at the 3-page motion to dismiss. It's not titled motion to dismiss. I'm going to call it a motion to dismiss.
Yes.
That's what we have,
It was
right?
my understanding that it was a notice of a motion to dismiss, but that's what you have, and I believe you have my opposition as well to the motion to dismiss.
So does it matter that the facts bearing on when the complaint itself didn't plead that there were injuries at the time of the rape? That was only evident from one might argue, that was only evident from the medical records that were attached to the opposition to the motion to dismiss. Does it make a difference? I mean, when we look, a complaint doesn't have to affirmatively plead that it's been brought within the limitations period. As far as I know, that issue was raised by the motion to dismiss. Once it's raised, how are the facts bearing on when the cause of action accrued determined? On the face of the complaint, or does there need to be discovery?
Well, Your Honor, I don't think it needs to be discovery. I think based on the cases cited in my brief, that discovery led to all of the decisions made after appeal, because there was some sort of additional facts after the complaint. But I do think that the complaint on its face has enough there to show that there was not a connection made at the time of her initial typical rape injuries to these subsequent
But
injuries.
does it affirmatively show that, or does it just perhaps omit some facts about injuries that did occur at the time of the rape?
Well, I don't think the rape injuries are necessary for the complaint to survive, because those aren't the injuries that she is seeking.
Let's assume that if those injuries were established, that would have started the statute running, so that it was filed too late. Does it matter that evidence of that was not alleged in the complaint, and it wasn't established by the motion to dismiss? It was only brought in through the opposition to the motion to dismiss, an attachment to the opposition.
Well, I think because it wasn't brought in the motion to dismiss, and perhaps the facts of her typical rape injuries weren't included in the complaint, kind of nullify each other, that there's, again, still enough there to support them.
So there's no obligation, so you have a complaint that doesn't affirmatively establish that the complaint is time barred. and then you're faced with a motion to dismiss. Is there any obligation at that point to amend the complaint to add allegations?
There could be, yes, Your Honor. And had that been addressed by the defendant, that is perhaps the course of that the plaintiff would have taken. However, the motion to dismiss was heard before any other pleadings were filed.
But you can amend as of right at that time, right? No answer has been filed?
Absolutely, Your Honor.
Are you aware of any case that says, faced with a motion to dismiss, the plaintiff has an obligation to amend the complaint?
No, I don't know of any case that obligates the plaintiff to amend the complaint.
Or do you know of a case that says the other way? Do you know of any case addressing this issue?
I don't, Your Honor.
Okay.
Anything else? No. No. All right. Thank you very much for your argument. We have no brief from the appellee, so we will take the case as submitted.
Thank you, Your Honors.
All right, our third case will be number 24P4 in the matter of Julia Elizabeth Rice, and we will be taking about a 15-minute break after the third case. So those of you who are here for later cases can plan accordingly. Good morning, Attorney Reeser.
May it please the Court, I'm Dan Reiser. I'm here on behalf of the appellant Catherine J. Connors as the nominated representative of the state of Julia Elizabeth Rice. We're here arguing against a, a ruling of the Middlesex Probate and Family Court, July 11, 2023, where Judge Gargis reversed 18 months and 6 orders where she had refused to allow Susan Rice, one of Libby Rice's sisters, as special personal representative, to waive the estate's privilege. She reversed that in this order on the July 11th and allowed it to go forward. We argue that there was no factual legal basis for that. It was abuse of discretion and it should be reversed. The order itself, if you look at the July 11, 2023 order, clearly states that it has 2 bases. It was based upon 2 things, the recent submissions, meaning their motion, which I refer to as the privilege motion, and our opposition there too, as well as there was a ruling in the wrongful death case that was brought by Susan Rice as special personal representative in the Middlesex Superior Court. There was a motion for judgment on the pleadings, and there was a ruling there. I'd like to address each of those individually. As to the waiver motion, it's clear from that motion that it's solely based on 2 documents attached there to Exhibits B and C. It's clear from the motion.
The judge changed her mind about the law. Would you agree with that? She changed her mind about what was either permissible or appropriate for a special personal representative.
I would agree that she had changed her mind, but I would argue that it was based upon impermissible grounds.
What's impermissible about a judge saying, hey, you know what, I've rethought this, I've considered the decision of another judge in a related matter that makes me see the law in a new light. I think I need to change what I did before because it was legally wrong. Or perhaps, what I did before was an abuse of discretion, or I'm exercising my discretion differently now, even if it wasn't an abuse before. What's to prevent a judge from changing her mind?
Well, the judge doesn't say any of those things. She doesn't say she changed her mind on
We
new
don't
law.
tend to.
I'm sorry.
We don't tend to when we change our mind. I mean, she's allowed to enter a different order.
Well, she's allowed to enter a different order if it's based upon something that was a reasonable basis for changing her position. Sorry.
And why would the decision of the Superior Court judge discussing the ability to waive by a special personal representative not be a sufficient ground for the Probate and Family Court judge to say, you know what, I think I'm going to change my mind on this?
Okay, so the 2 bases, I think you're referring to the ruling on the motion to quash, which was not one of the bases for the waiver motion, the waiver ruling, and it wasn't before the judge at that time. They base it on their briefs.
You're saying she can't take notice of it?
I'm saying that there's no evidence she did. So to read into, I mean, they try to do that in their brief. They say, forget about the stuff we filed beforehand. Let's
We
at
look
this
for
new
whether, what the judge could reasonably have done. The judge doesn't have to show all her work. The question would be whether it was an abuse of discretion to change her mind or an error of law. I mean, let's look at the correctness of what she did. That might be a better place to spend your time.
Okay, so, well, I guess if you're going to say the legal correctness of what she did, then if the privilege does pass to estate fiduciaries upon the death of the decedent, the only estate fiduciaries at that time were my client and Sally Lurie as co-defendants, co-trustees of Libby Rice's trust.
Well, she had been appointed, Ms. Rice had been appointed a special personal representative.
Afterwards.
She was appointed, I thought, appointed and then extended 4 or 5 times.
Yes.
And then she was she filed a new motion along with her motion for to reconsider the privilege waiver issue, and it was allowed.
Yes, so just to establish the facts, I know you told me not to go into them, but I think they're relevant here. Libby Rice, unfortunately, took her own life on January 23rd.
We know the
No,
facts.
we don't need to go that far back.
The SPR appointment was not till January of 2022.
It was September 28th, 2021.
I think that was the original Mr. Mayor. There was one before her.
I'm sorry, you're totally right. That was Mr.
So
Mayor.
I believe, I can find the exact date. My memory says it was January 1 of 2022.
January 19th, 2020.
Okay, I was close. I got the one.
A trustee of a testamentary trust doesn't have the authority to exercise or waive the decedent's attorney-client privilege, does she?
I think so. 'Cause the case law talks about outdated terms. It talks about administrators, executors, but it talks about...
Okay, so now we use the term personal representative, whether it's a general or a special, but your client was never appointed. She was nominated in the will, apparently, but she was never appointed a personal representative. She never sought appointment. She never opposed the appointment of Ms. Rice. She may be a trustee of a testamentary trust, but maybe we could back up and ask, what standing does she have to appeal this order or to object even to the appointment and the terms of the appointment of Ms. Rice?
Well, I think she does have standing. Under Chapter 190B, Section 1-20124, I believe that she falls under the definition of an interested party.
Well, there's a decision out of this court earlier this year. It's called, sorry, it's taking me a moment to find it, but it is the Birkenfeld case, State of Birkenfeld, which basically says that simply because you're an interested person does not give you standing, and that common law principles of standing still control. So when you have to be able to show an injury.
Well, I think the injury here is twofold. That goes to their argument that she's not an agreed party to go before the probate court. So as the trustee of the trust, and if you look at Exhibit B, and I think C as well to the privilege motion, it makes it very clear that Libby Rice had a testamentary intent that her 3 sisters not be involved in postmortem issues, and that her co-trustees were to handle all those things. This wrongful death witch hunt, whatever it may be, is exactly the type of thing that Libby Rice was trying to avoid. As the co-trustee of her trust, she's trying to enforce that testamentary intent.
But what standing does Catherine Connors have to raise that? And I'm sorry, I didn't have the citation before, but a State of Birkenfeld, 103 Mass Appeals Court 628. Being an interested person under Chapter 190B, Section 1-20124, entitles one to notice in certain circumstances, but doesn't displace the common law requirement of standing. In other words, a legal interest in the decedent's estate.
So the legal interest, again, I'm sorry that I'm repeating myself, but I do think it is the basis of it is that she was tasked as a fiduciary to protect the testimony interests and desires of the trust the trust grantor. And that's exactly what she's doing here. There was no desire that her sisters would be dealing with these post-mortem issues, and she's trying to protect that intent. And as well, I would
her duty as a trustee would be to administer the trust,
yes.
not to execute the wishes of the decedent in other regards. And the trust basically distributes keeps the trust assets and then distributes them in accordance with the trust. How does the trust have an interest in whether additional assets are added to the trust as proceeds of a lawsuit? Does the trustee have a standing to oppose the addition of assets to the trust?
Well, I don't know what this is going to result in additional assets.
Well, it's not going to result in fewer assets to the trust, is it? I mean, if it was going to diminish the trust corpus somehow.
Well, the trust is incurring expense for the legal fees that are involved with these matters.
The trust
Trust is defending the case?
The wrongful death case, I believe, is handled by insurance. I'm not involved in that case, so I can't say. But
well, I don't know how the trust would be paying for that.
Yeah, I don't believe it is. I think it's correct.
So what injury is there to the trust from the wrongful death case? Or from the ability of the special personal representative to pursue that case?
I think that the injury is, I guess I would disagree with the court that the testimony intent is not part of the protection of that is not part of the trustee's role. You know, the trustee is to fulfill the trust along with, as the expressed wishes of the grantor. And I would argue that at very least Exhibit B, which was done after the trust but prior to death.
Do we even have the trust document in the record?
No, in my brief I stated that we would produce them in camera if they wanted, but because we were afraid of a waiver of privilege from producing them.
The trust document is attorney-client privileged?
It's part of the file that they were trying to get.
Okay, but that doesn't make it attorney-client privileged, does it?
The answer is no, it's not before the court.
Okay, but we can't determine what the intent of the decedent as expressed in the trust document is.
No, but I would argue again.
And that was that even before the trial court judge, the probate judge?
About what the intent was?
Right, so you're arguing you have standing to further the intent of the trust settlor, the decedent. Is there any evidence in the record of what that was, if there's no trust document in the record?
Well, there's the exhibits to the privilege are in the record. The exhibits.
You mean the memorandum?
There's the memorandum, and that's the letter to her sister, where she directly, in the first couple of lines of that letter, she says, I don't want my sister's.
But when we're interpreting a trust, do we look at a letter that someone wrote outside the terms of the trust, or do we look at the trust document itself?
I would argue that letter amended the trust document. That was the intent of it.
I'm sorry?
I would argue that letter amended the trust document. That was the intent of it, was to express additional desires.
That's a pretty free-floating fiduciary duty you are proposing for a trustee to have a duty that is broader than that is described in the trust document, which we don't have before us, and that is potentially amended by documents that, at least according to your client's position, were not drafted by the law firm and were not part of her estate.
Well, our position is they were drafted by her. I think that they show that. And so that they're even more forceful of what her intent was. Now, I also would argue that, this issue, my client has filed plenty of pleadings in this case opposing the extensions of the SPR, opposing the waiver motion. Standing has never been raised in any of them. Well, it wasn't raised until this. No, I understand it can be raised at any time, but
okay.
But my point is that, it's the second argument in their brief after 2 pages of yelling at me for making my appendix too long.
We're focused on the substance.
Yeah.
And we can't ignore the standing question.
I understand that. So going back to while I still have some time, going back to the issues of the basis, the stated basis for the motion. There's the waiver motion that has B and C, which are completely misrepresented to what they are and what they mean. They're not supported by an affidavit. The argument was that these were drafted by the law firm, therefore they show the law firm had prior notice of the desire to commit suicide, and therefore the records are relevant and there must be a waiver. None of that is true. They're not supported by affidavit. The opposition's had affidavits from the lawyers who drafted the estate documents that said we didn't draft these documents and we had no prior knowledge. So I think that the basis upon which this whole matter was presented to the probate court was either innocently or otherwise misrepresented as to what the need was for the waiver of this privilege. As the MJOP ruling, that too, I believe, was misrepresented because it's not a ruling on the merits. And the Barish case cited in my materials, and in the order itself, quite frankly, say that. It's not on the merits. It's not a ruling on as to admission of evidence.
Not. It's a ruling that the some aspects of the complaint, viewed in the proper standard, can survive a motion to dismiss, in essence.
That's all it is.
Okay. How does that bear on whether the waiver, granting the authority to waive the privilege was proper? There's obviously a complaint that at least survived a motion to dismiss or a motion for judgment on the pleadings. So
their position is that Judge Gargis looked at that and said, you know what, this case has more to it than I thought it was. It's okay to waive the privilege.
Well, does Judge Gargis have to go that far in order to say, I'm going to allow the waiver of the privilege?
Well, she stated it was one of her bases, so she considered it in some grounds, and their conclusion is the reasonable one. But I don't.
What she could conclude from that is that the motion for judgment on the pleadings was denied as to your client individually. Mm-hmm. So it's a live case, and it stands to add to the estate.
It's possible, but
Sure, no one's judging what the ultimate outcome is.
But if you piece it together from her prior rulings, the first appointment showed a lot of skepticism as to the merits of the underlying claim. And then all of a sudden, 18 months later, and that's consistent throughout, and then all of a sudden, when this ruling comes in, she reverses position. So I think it's a reasonable basis. And I do want to say just quickly, if you look at page 20 of their brief, in the first paragraph, they say it's sound reasoning, she could change her opinion posted on that.
Okay, so one can plead and argue in the alternative. One can say, we agree with the judge on this, we don't agree with the judge on that.
I understand that, but to say that and then the next breath to say it was error for her to let the merits of the case seep into her orders, I would agree that they were right the second time, not the first.
Thank you.
Thank you very much.
Mr. Hahn.
Good morning, Your Honors. Alex Hahn for Susan Rice, who's here today, and Thomas J. Frayne with me as well. Just respectfully, Susan Rice lost her sister to suicide, and for Mr. Reiser to say she's on a wrongful death witch hunt.
Let's just focus on the merits, okay?
Very much, Your Honor.
Avoiding adjectives and adverbs to the greatest extent possible.
Yes, Your Honor. If Libby Rice were alive today, there's no question that she would have a right to her file at WCN under Rule 1.15a of the Rules of Civil Procedure.
Right. So, and it's established that a personal representative can waive the privilege, I think, by the cases that have been cited. Does it make a difference here that that Ms. Rice is not a general personal representative, but a special personal representative?
None whatsoever, Your Honor. The statute on that, General Laws 190B, Section 3-715, as Justice Ellis tells us, in her opinion on the motion to quash, there is no difference for purposes of prosecuting civil litigation.
Well, that's not exactly what Justice Ellis says. I mean, she says the personal representative has this laundry list of capabilities. The special personal representative has a few of those carved out.
Yes.
My reading of the difference is that most of the carve-outs have to do with the ability to dispose of money in the estate, to settle claims, and so on.
Yes.
And then goes on to say, therefore, she can prosecute the lawsuit. Justice Ellis never says, I think, the rights that are imbued in the special personal representative include the right that the personal representative undoubtedly has to waive the privilege. Do you have a case that says that the ability to waive the attorney-client privilege is vested in a special personal representative? I know all the cases you've cited about the personal representative, that is established, but the special personal representative.
No, Your Honor, I don't believe there are any cases, but I very much read Justice Ellis as saying that when you have a special conducting litigation, there's no sort of differences in power at that point. A special and a general, either of whom is prosecuting a lawsuit, is going to have coextensive powers. I read it very much like that, and I certainly haven't read any case law to the contrary. And at the time the subpoena was served, there were no restrictions. So the sequence, I think, is important. Ms. Rice becomes the special and serves this subpoena, and at that time there's no delineated restrictions on her authority. At that point, Ms. Connors goes back to Judge Gargis, who expeditiously enshrines these restrictions. And at first, her first order says no waiver of the privilege. In January 2023, she adds another restriction saying, I do not authorize any inquiry into the decedent's will or trust. That restriction never made any sense. Libby Rice made an estate plan and a will in December 2018 and was dead in January 2019. And the will nominated Ms. Connors, and Ms. Connors ends up being represented by WCN. So that was a glaring conflict of interest that Justice Gargis took care of. But the notion that one would not want to discover that information and that Judge Gargis would get in the way of that, never made any sense. This case boils down to, as Justice Sachs says, did Judge Gargis have the right to change her mind? And absolutely, a judge is never precluded from doing the right thing, from following the law, from correcting an error. In this case, she corrected an error based on an order that restrictions that were fairly inexplicable, but she did change her mind. And her earlier orders never explained why, never articulated any basis for this. And I understand it's the probate court and we don't get fulsome opinions on everything, but the judge, it was fiat. In the order removing the restrictions, she does have a basis. She cites to the denial of the MJOP. I agree with Justice Sachs. The content of the complaint as such is irrelevant at that point. Justice Gargis, I don't think she did go back and review the complaint. There's no indication of that. And why would that be necessary? She's just looking at the fact, not any evaluation of the merits. She's looking at a case passing over a motion to dismiss, something that's not without teeth. It's a sister judge in the trial court department admitting this case to discovery. And Judge Gargis said, yes, I'm going to change my mind and allow the waiver of the privilege.
Why was it inadequate to review the documents as opposed to having a complete waiver of the privilege?
Inadequate for us to review them? In terms of us being potentially given access to them by Mr. Reiser. Mr. Reiser would have to have gotten the documents from somewhere. From WCN, and I did have congenial conversations with Mr. Reiser about this. We ultimately concluded we have no basis for trusting WCN about anything, and certainly not turning over the full contents of the file.
So you were concerned that it was not a question about the use of the documents. You were concerned about the completeness of a production that would have been obtained that way.
Exactly, Your Honor. We ultimately concluded that, notwithstanding, I think with Mr. Reiser, there's considerably more trust, but all that is irrelevant. We want to use the tools of civil procedure. When you receive a subpoena as a law firm, the custodian has to sign something. We want all of that. We want what the civil discovery tools allow.
So can you address the standing issue? You agree she's an interested person. You agree that she's, at least under the statute, Ms. Connors, you agree that she's the nominated personal representative. I think you agree that she is one of the trustees of the testamentary trust, or the revocable trust, I guess it is.
No, Your Honor, I don't agree with much of that. We state in our brief that we don't believe she falls within the interested party aspect. So forgive me if that wasn't clear, but I'm pretty sure we stated in our brief that she's not. This trust
thing kind of comes right out of left field. It wasn't raised below. It wasn't raised in the principal brief. And I'm a little godsmacked that Mr. Reiser's telling us he can make an argument based on it, but they won't give it to us. And they're saying it's in this WCN file. That should never have been withheld. That's not a privileged document. We're seeking her whole client file, but they should certainly produce non-privileged documents, especially if they're going to argue in the appeals court that those documents make their case for them. So if it's an integrated, signed document by Libby Rice, they should have given it to us. Before I lose my time, Your Honor, I realize I have a little, but this is an interlocutory appeal, and we opposed its existence, and we are here today, but the existence of the appeal is serving a purpose of obstruction. We served the subpoena.
Can I,
yes, Your Honor.
Can I back you up now that I have the definition of interested person
Yes, Your
in
Honor.
front of me? It includes persons having priority for appointment as personal representative. Would that include Ms. Connors, who was named in the will?
I would have to read the statute. I'd have to think if they take no action to become the...
I'm just looking at the definition of interested person.
I certainly think, as you just read it, that would put her with an interested party, yes.
And other fiduciaries representing interested persons. So if she's a trustee of a trust, I don't know who all the beneficiaries might be, but would that be sufficient to make her an interested person?
I don't see how being the trustee would give her an interest in these proceedings. I mean, these proceedings have to do with Susan Rice's appointment as the SPR, and she never once raised her hand below and said, I'm the trustee, and therefore we shouldn't let Susan Rice be the SPR. This is rather late for these arguments, and they're also saying, well, it's based on a trust that we don't even get to see. So I don't think that that part would make her an interested party in these proceedings. And where it was going, Your Honors, is there are practical aspects of this. So it's been very difficult below to get documents. It's been impossible to get these ones. The subpoena was served a year and a half ago. So there's been a lot of delay here, and we would ask very humbly if there is an order affirming that it make clear that that order is not stayed by any subsequent appellate activity. I believe that's the law anyway, but I would hope it could be delineated, because where I'm going with this is if Your Honors affirm Judge Gargis and we can then go reserve the subpoena, we are exceedingly confident that they will file a FAR petition. They will go back to the Superior Court and create confusion, as has happened a considerable number of times, and say this motion, the file should remain quashed unless and until the SJC completes its review. They've fought mightily to prevent scrutiny of this file. Mr. Reiser says in his brief, much ado about nothing. I don't see why they would not turn it over, and why they have spent, I can tell you the amounts that Ms. Rice has spent, which have not been provided by the trust has not funded this, have been staggering to get this file that we sought in June 2022. Everyone should want this file scrutinized in the interest of justice. It's relevant. I could never do as good a job as Justice Ellis did explaining why it's relevant and why the SPR ordinarily has the authority to get it. I cannot improve upon that. And it is a simple question of law. The issue Mr. Reiser raises about the dueling allegations about the control numbers, no longer relevant. I certainly would not want my control numbers floating around on the person who is talking about their decease and then commits suicide, but that's that's gone now. Judge Gargis decided this as a narrow matter of law, and it comes down to that. Does the judge have the authority to change her mind? And she did. and she should have never had those restrictions to begin with, in our view. But, our hope is we get an affirmance of Judge Gargis, and hopefully, again, this is interlocutory, and it's moved at, I think, a traditional pace. I've never been clear if there's any difference in how the interlocutories move through the appeals court once allowed, but we would like to get these documents. Parenthetically, I'll just tell you that in the discovery below, Ms. Connors does have some of the documents that are from this file. So the privilege has been lost, obviously, and what appears to have happened...
That's not really for us to deal with, is it?
Fair enough, Your Honor. I apologize. I'm far afield. Are there any other questions from the panel?
Nope.
Thank you very much,
All right.
Your Honors. I appreciate it.
Thank you both for your arguments. We will take our morning recess now, 15 minutes, and we'll be back.
Court, all rise.
All right. We will pick up with our second group of 3 arguments, the first of which is number 23P 1496, DCF versus Father. Just a reminder, I'm sure as counsel are aware, this is an impounded case, so just avoid names.
Thank you, Your Honor. I'm Madeline Blanchette, and I'm here to represent the father appellant. This is a case that demands vacating the termination decree because the lower court failed to hold DCF to its mandate to provide reasonable efforts at reunification, and the ultimate finding that reasonable efforts occurred here was clearly erroneous. I want to bring the Justice's attention first, please, to the decision of the lower court at the 72-hour hearing. That hearing did not occur until December, although father did present in lower court in September. He did file his paternity action immediately then, but he did not get adjudicated the father until December, and so that's when he got a 72-hour hearing. And unfortunately, the lower court at that time, while she did acknowledge that he had not received reasonable efforts for reunification either prior to adjudication, which she said was permissible, and which I disagree with, and that he, even after adjudication, continued to not receive reunification reasonable efforts. And then she failed to make any remedial orders. So I would say that was the major first problem in the case.
Counsel, can I just pause you for a moment? I'm trying to find that transcript, and I'm not seeing it in the transcript appendix. Is it somewhere else?
It's in the record appendix 1, pages 27 and 28, Your Honor.
Thank you.
So she said, father was not provided with specific information about the child due to his then status as a putative father. Even after he was adjudicated the legal father, the department did not provide him with specific information about the child and her needs. So at that point, under Walt, she could have returned custody to the father, or even if she wanted to maintain temporary custody with the department, that was her opportunity to make remedial orders to ensure that reasonable efforts were being made to reconnect the child with her father.
All right, but what efforts were not made after that point?
Well, Your Honor, the case is, luckily there's some real markers that show that, again in June. So I think it was only a matter of 6 weeks or a couple months after the 72-hour hearing, they changed the goal to adoption. And then apparently father was so distressed by that he filed this motion in June called father's motion to force DCF to provide reasonable efforts at reunification. And in that motion, he raised a couple of important issues. One, which was around reasonable efforts, that he was being forced to choose between attending visits with mother, whom he was roundly condemned for associating with, or having fewer visits with his child. And again, he was being denied access to information about her special needs, being denied access to attend medical appointments. I would also—
The judge entered an order after that, right, on that motion?
Your
one
Honor,
in June 2021, where she ordered certain remedies, right?
She said that she explicitly didn't have the power to order a remedy, and that she said that the more appropriate forum for this motion would be at the permanency hearing.
So then the SJC decides Rashida a little later, and does he come back and say, no, Judge, you do have the authority?
Your Honor, he does not. There is a permanency hearing on July 1st, which is another very problematic event where DCF is posing now to the court for permission to change the goal, presumably from reunification to adoption. And the lower court makes a finding in the docket that that was an appropriate goal change. And then very significantly, he says that DCF has made reasonable efforts on a goal other than reunification. So that's erroneous because the goal was allegedly reunification prior to the moment that he allowed the goal change. Personally, I think that that is the truth, which was that DCF was not working towards reunification. They were working towards another goal, which is sort of this self-fulfilling prophecy and shaping the facts of the case.
Okay, but so trial occurs in August 2022, right?
Yes.
So looking at the case globally, what efforts should the department have provided but did not?
Your Honor, I would say initially having a once-a-week, 1-hour visit with the child with a newborn is insufficient to, to really allow for bonding. I outline in my brief the very unfortunate dictation notes from those visits where there was this is a first-time father, a man in his 50s. There's very little encouragement. There's very little teaching. There's a lot of
Did he ask for additional visits?
I think what I'm arguing here, no, he did not file a motion for visits, is the answer, and that would have been the lower court's opportunity to make those remedial orders for reunification style reasonable efforts.
But he didn't. So he doesn't ask. He missed a number of visits, the ones he was given, right? You don't dispute that.
Over time, he did start to drop off on visits. That's correct.
So I understand maybe there was, DCF did not do certain things at the beginning of the case, but looking at the case as a whole, I'm not seeing services that he asked for that were not provided.
Well, Your Honor, he doesn't have to ask for services. The burden is on DCF to provide reasonable efforts to reunification.
All right, so what services did DCF not provide?
So, I can throw some out that I think would be tailored. The major things that they criticized him about were a lack of understanding of the special needs of the child. He did file a motion for that. That's the motion in June. Also, that is something that Judge Phillips highlighted.
A motion he asked for more information about the child's medical needs, right? And then I thought in that order, the judge said that the department agreed to provide that information.
They did. So at that point, he had not, so that's in June, he had not been allowed to attend any medical appointments, even though he had asked, and that's in the record.
After that, he was.
And then after June, there was like a negotiation which the judge codified. And then I think in August, he was invited to a visit. What I'm saying, though, is that the things that they faulted him for, they controlled the narrative around. They held possession of the child. They did not provide generous visitation for a newborn. They criticized him for his lack of knowledge about the mother's substance use. They don't refer him. They don't give him a parenting aid. They don't encourage his family to come in. These are some things that he did ask for. Instead, they give him this boilerplate plan that is not carefully tailored to what their main criticisms of him. And I do think that, then when the lower court had the entire case at that at the termination trial, and he did have to review all the material and make a fresh determination if there were reasonable efforts to reunification. It's really like 0 plus 0 plus 0 is 0. Like there is no finding in this record that DCF provided reasonable efforts to reunification. So that at trial, father continued to have infirmities. While I'm not conceding that, even for the sake of argument, if that were true, I mean, it's fundamentally unfair to his substantive due process rights that he would end up at trial never having been given a meaningful pathway to reunify with his child.
So what are we to make of hearing your point on DCF was offering the wrong things? I don't think that it's been argued or that the evidence has established that those things were irrelevant or completely unrelated to the parenting. And the record is that the father did not follow through with them. Was the judge entitled to consider that in the determination of the father's fitness to parent this child?
Your Honor, in terms of the father respectfully declining, for example, therapy, yes. I mean,
Therapy, the parenting class.
the parenting class is more complicated because he did make attempts at that and he had all kinds of problems with connectivity. But, it's very clear. It's in the record. The court investigator acknowledges that father had no mental health concerns. He had no substance concerns. I mean, mother is undoubtedly unfit. To sort of, so he respectfully declined mental health services. That is correct. And I think that while the lower court can take notice of that, I mean, it's not at the nexus of the parenting, of even what DCF said the parenting concerns were. I do want to also just mention, I know my sister points to Ilona and says that even in a case where reasonable efforts have not been provided, the lower court can still terminate rights. That is correct, but what needs to happen there is there has to be an actual correct finding that there were no reasonable efforts, and then that's balanced against the best interests of the child. That didn't happen here. There was just, I mean, DCF has so much discretion, and there are a few guideposts along the way in the trial court, and somehow this case just blew through all of them.
I just want to make sure I'm understanding what you're arguing. So you're saying that there was no finding in the judge's ultimate decision that the department made reasonable efforts?
Did not make reasonable efforts. If he had acknowledged that they did not make reasonable efforts,
Are you saying that there's no finding at all, or are you saying that the finding was erroneous?
I'm saying his finding that there was reasonable efforts is clearly erroneous.
Oh, okay.
Because there's nowhere in the record.
I thought you were saying that the judge didn't make a finding at all.
No, I'm sorry, Your Honor.
okay.
No, he did make a finding, and it's not correct. What I'm saying is that up until his erroneous finding in the termination decree, there was no finding that DCF along the pipeline. It didn't happen at the 72-hour hearing. It didn't happen when he filed that motion in June, and it didn't happen at the single permanency hearing on July 1st. There's no finding in the record that DCF ever provided reasonable efforts for reunification. Again, I have an entire second argument, which I would just say that even the infirmities that DCF is criticizing my client for, I don't think that they have a nexus. they don't show the appropriate nexus that's needed. So he was never proposing that he would give the mother unfettered access to the child. He was always saying that it would be supervised visits. And in fact, DCF is aware, it's in the record, that she has unsupervised contact with her older children. That's in the record appendix at 348, and then the social worker testifies that on page 96 of the transcript. Also, the foster mother testified that she would allow the mother, that's at transcript 90, that she would allow the child to have access to her mother. So for all those reasons, the reasons in my brief, I respectfully request that the termination decree be vacated, the case is remanded, but also specifically with an order that DCF provide reasonable efforts for reunification. Thank you so much.
Thank you. We will hear, I believe, from the department for 10 minutes and then from the child for 5. So.
Yes, Your Honors. Good morning,
Right.
and may it please the Court. Catherine Fahey, Assistant Attorney General, appearing on behalf of the Department. The Department respectfully requests that this Court affirm the Juvenile Court's decision terminating father's parental rights. Termination here was supported by clear and convincing evidence that this child has unique and evolving medical needs, and that as a result of being substance exposed at birth, and that father is not equipped to meet those needs. Specifically, the trial court properly concluded, based on the record, that father lacks an understanding of child's medical needs, and he was inconsistent in his efforts to understand or address those needs.
So
Further,
at page 28 of your brief, at the beginning of your clear and convincing evidence argument, you say the juvenile court relied on father's unwillingness to engage in or benefit from services or to cooperate with DCF to demonstrate his ability to provide for the child. Is it the father's burden to demonstrate his ability to provide for the child?
it is not, Your Honor, and it was not my intention to reflect that in my briefing. In fact, it is DCF's burden certainly to demonstrate by clear and convincing evidence of father's unfitness.
Just say for the future,
absolutely, Your Honor.
Go through your brief at the last minute, searching for the word demonstrate, and make sure that you're not burden shifting.
Certainly, Your Honor. And to that point, I'm happy to address DCF's efforts to engage with father and to turn directly to Attorney Blanchett's argument regarding reasonable efforts, if that would be most helpful. DCF had provided father with a service plan before paternity was even established in this case and began to engage with him as early as they could, acknowledging the fact that paternity was not resolved until December, and a 72-hour hearing as to father could not be held thereafter. From the beginning of this case, however, where DCF had a founded report of neglect and had properly intervened and taken temporary custody of the child, DCF saw that there were certain efforts, there were certain deficits on both father and mother's part that could be redressed with certain services. At every instance that DCF directed father to services such as individual therapy or parenting.
Why did he need therapy? The judge found DCF told father to get individual therapy to work on addressing the issues which led to DCF's involvement. Why does that necessarily indicate therapy? Why not parenting classes or in-home support or some other services? I mean, does every case require therapy?
My understanding is that the department prescribes services as it sees appropriate based on the unique needs of each and every case. Here, the department prescribed or requested that father participate in a parenting assessment, which may or may not have led to additional services, certainly. They requested that he participate in a drug screen. They requested that he participate in parenting classes, repeatedly requested that he
But the judge is concerned that
and yes, they requested that he participate in individual therapy. And I cannot speak to how the judge saw that fit into the picture, but based on the evidence that was before the judge at the time, he thought that would be appropriate. And I would note that the evidence before the judge at the time was that father was not understanding or credibly testifying about his understanding of the gravity of the situation, right? This child was born substance exposed, had health issues that emerged over the course of 2 years prior to trial, and at various points, father reflected that he did not think that mother had been using drugs, despite being informed as such.
Certainly the child was born substance exposed. After that, what risk of abuse or neglect did the mother pose to the child such that access to the child, if the child were returned to father, why is it that the father's openness to allowing the mother to see the child would pose a risk to the child? What risk does the mother pose once the child is born?
Your Honor, I think it is less of a concern about immediate risks and more of a concern about father's ability to parent this particular child overall, right? And I think there's also a concern based on the trial court about the ways in which father is interacting with DCF, his inability to cooperate, his inability to be forthcoming about the interactions he's having with mother, such that DCF can't predict what the circumstances will be. And I will note that father himself has testified about how mother behaves when she is on substances, right? And so it would be reasonable for the department to have some concerns about the ways in which mother may interact when using substances with child. And so I think all of those pieces went into the court's decision.
But if he had, let's say he had complied with the action plan and had an appropriate home for the child, would his continued relationship with the mother have prevented him from gaining custody?
I can't say necessarily, Your Honor, because I can't put myself in the position of the juvenile court judge, but I think it is important to emphasize that in this case, it is a constellation of factors, the most important of which is the unique medical needs of this child and father's unfitness to meet those needs.
So going back to Justice Sachs's question about therapy, so there is no evidence in the record as to why that particular task had any sort of connection to a perceived deficiency, right?
There's nothing that I can point to directly at hand, Your Honor.
So it's error for the judge to rely on a failure to complete a task that's not tied to his deficiencies, right?
I'm sorry, Your Honor. I just want to clarify. My understanding is that individual therapy was prescribed to redress the issues that led to DCF involvement, which includes mother's substance use and father's interactions with mother, right? So I can't point to something in the record that's
Therapy is
expressed.
designed to address what exactly?
That's the piece that I can't point to.
Okay, so then it's error, right? I mean, so failure to comply with an action plan, we know, is relevant to a fitness finding, but the tasks still have to be tailored to the particular parent, right? So the judge can't rely on a failure to comply with a task that's not tailored to the particular parent.
We're not suggesting it's necessarily
Sure.
reversible error, but
Yes, absolutely. And to respond to that, I agree, Your Honor. I think the point to emphasize here, though, is that it was one of numerous tasks.
I understand, right.
And my understanding of the service plan globally as to father was that it was all designed to redress the deficits that father was exhibiting here and to ensure that he could support this particular child.
One of the
And he was unwilling to
findings,
work with those.
one of the findings about the father's parenting deficits is that apparently the judge found it remarkable that the father would discipline a 2-year-old child by giving her a timeout in a corner. Is that universally acknowledged to be inappropriate discipline? Is there some DCF regulation that says that's impermissible?
Not that I'm aware of, Your Honor. I think the court focused on that testimony amongst other comments to reflect father's, as the decision discusses, father's rigidity and inflexibility, two issues that would have presented a problem here where this child is, over the course of the first 2 years of her life, she's exhibiting an increasing number of neurological and other health issues that require special attention, and where father is exhibiting a level of rigidity and inflexibility, including, as you point to, this point about timeout, but also saying that she doesn't hear no frequently enough, dismissing her neurological issues as simply blonde moments, right? Each of these comments appear to support the court's conclusion that father would not be sufficiently flexible to work with this child and her needs. Just turning back to reasonable efforts briefly. So I think it's clear to the panel, but if it's not, I'm certainly happy to emphasize. The department's position is that the juvenile court did conclude DCF engaged in reasonable efforts. So we disagree that there were no reasonable efforts here. From the point at which, as I've mentioned earlier, from the point at which father was known to DCF, they began communicating with him, engaging in service plans. He had access to child. He had the opportunity for visits. Irrespective of what occurred and what the juvenile court judge found at the January 2021 72-hour hearing, reasonable efforts occurred from January 2021 until the point of trial. And I think it's important to emphasize that father cannot simply throw up his hands where he has chosen not to engage with DCF and blame DCF for a failure to engage in reasonable efforts where he doesn't fulfill his own obligations. Additionally, I think at this point, some of the services that I was hearing Father's Counsel point to were services that were not raised previously, and certainly it's waiver to argue now that there was inadequate services where they were not previously provided.
Okay, thank you.
Thank you.
We'll hear from Child's Counsel.
Good morning, Your Honors. May it please the Court, Gary O'Brien, excuse me, on behalf of the appellee child. The child is, we're in support of the department in terms of the arguments that's been already discussed with regard to reasonable efforts and with regard to the unfitness and upholding the decision of the trial court. In particular, on behalf of the child, what I think we noted and set out in the brief were the really unique needs and the status of this child who was born substance abuse, spent 3 weeks in a hospital, was released to the foster mom where she remained throughout the entire pendency of the case. The foster mom continued to address and work on all of her unique special needs. On page 21 and 22 of our brief, we go through all the different doctors and specialists that she was seeing. In terms of sensory issues, she was constantly, with each food, having to kind of look in terms of her reaction to be able to address whether or not that was going to provoke a response. So the issues with father were really the unfitness, father's inability really to address or even engage in services with the department, which I think was his responsibility in terms of reasonable efforts. The department can say, these are the services we'd like you to do, but under Mario case law and other cases, the parent at least has some responsibility to participate and kind of address some of those things, which he didn't do in this case. And then you combine it with the child's unique needs, his home, where he again and again canceled appointments. The department didn't even from August until February.
Well, very roughly, I looked at the number of visits that I think DCF's brief said he missed, and it might have been somewhere between 20 and 25%. I'm not sure.
17.
17? Okay.
Are Your Honor talking about the parent-child visits?
Yes.
And I think he started to step up and miss much less visits as the case went on. What I was referring to was the department's social worker needed to come out and see his apartment, and he would continually cancel those home visits. And so part of the child's issues were asthma, sensory issues, and the fact of the mold.
And what was the most recent evidence at trial about the condition of the father's living quarters?
Well, I think that I don't think from August of 2022 until February of 2023 of the last day of trial, he continually, the department was never able to go out to reassess his home at that point.
Did they try?
I think they scheduled visits and he would cancel them or not be available or would not able to attend.
When was the last home visit?
I believe it was in August of 2022, right before the beginning of the second day of trial. And then the trial, the other issue that I think is also in the brief with regard to his relationship with mother is that a second child was born in father's apartment to mom in November of 2022. And so then the trial was reopened and additional evidence, a third day of trial, was held in February of 2023. And so from August of 2022 until February of 2023, the department didn't go out to kind of reassess father's home and look at some of the issues that were really concerning to the department that, you know, kind of in combination with child's special specific needs were part of their consideration of whether or not father was in a position to be able to care for this child.
It seems like a significant concern for DCF and for the court was the father's unwillingness to keep the child away from the mother after the child was born.
I think that's certainly part of it.
Is that do we know what harm is it that the mother would have inflicted on the child?
And I heard Your Honor ask counsel that same question, and I think it's not. I mean, part of the issue certainly is that mother's issues led to this child as well as the newborn born in November. All of those issues, but I would I guess propose that even afterward, mom had no interest in participating in services. She had no interest in parenting the child. So what effect, I suppose the best answer I can say is it's unknown, but it's as the department likes to say, a concern about what environment or what things mom would bring around or that child would be exposed to in mom's presence. Is she under the influence? Is she making the right decisions? If father is not able to either unwilling, unknowing, or doesn't want to know whether or not she's under the influence or isn't able to tell, if he's then going to leave her in a caretaking position with regard to looking after the child. I think a lot of those things are unknown. I don't think, to answer Your Honor's question, I don't know specifically what it is, but I think it raises an issue as to what kind of access mom would have to the child without any kind of foundation or knowledge of what's mom's situation. And I think that goes into the insight into the overall concern and ability. So I apologize for running over.
No, that's all right.
But, and if there's no further questions, I would rest on the remainder of the brief.
All right. Thank you for your argument.
Thank you, Your Honor.
Okay. All right. Our next case is number 23P 1184. Brian Hogan versus Commissioner of Revenue. I understand that Mr. Hogan, who is the appellant, is not present. And Mr. Trechikov, I'll let you get settled, but we are certainly, we've read your brief. We're certainly aware of the issues. We've read all the briefs on the record. You're free to make a presentation if you want to. I'm not sure we have any questions. If you prefer to rest on your brief, you're also free to do that.
Thank you, Your Honor. Just very briefly, Konstantin Trechikov, Assistant Attorney General, on behalf of the Commissioner of Revenue. There are two issues on this appeal. Did the appellant, who is the responsible person for the withholding and sales taxes for a corporation, overpay these taxes to the Massachusetts Department of Revenue? And if the overpayment actually occurred, did the IRS pay any money to the Massachusetts Department of Revenue such that if there is overpayment, that money would be due back to the appellant? And the answer to both of these questions is a resounding no, because the board has found, and that finding is entitled to deference from this court, that there was no overpayment whatsoever. In fact, the board has found that there is a tax obligation that has not been paid. There is an underpayment of those taxes before the department. So for that reason alone, the board was without jurisdiction to issue any refund under the plain language of General Laws, Chapter 62C, Section 39. And turning to the issue of the IRS payment, the record also demonstrates conclusively that the IRS, while it did receive certain amounts of money under the settlement in the federal bankruptcy case involving the appellant, it then applied those amounts of money to offset the appellant's federal tax obligations. And the board did a little bit of math that is on page 45 of the addendum. Those 5 payments that were dispersed by the IRS match exactly the amount that they received under the settlement. So, and there is, needless to say, according to the affidavit of the tax auditor, which the board credited, there is no indication whatsoever that IRS ever paid any money. So for all those reasons and other reasons stated in our brief, we are asking the court to affirm the decision of the board, and unless the court has further questions, I will rest on my brief.
All right. Thank you very much.
Thank you, Your Honor.
And our final case for today is number 23P1309, Chesler versus Ivanova. Hope I'm pronouncing that correctly. Good morning, Mr. Derlin. Whenever you're ready.
Thank you, Your Honor. Good morning, Justice Sachs, Shin, and Hirschfang. My name is Sandy Derlin on behalf of the mother in this case. As Your Honors are aware, my brief addresses 3 issues, 3 primary issues, 2 that I want to especially address here today, time permitting. And if the court has any questions, I welcome them. Otherwise, I'll start right in on argument. The issue of legal custody is certainly something I want to address. The bulk of the evidence in this case and the bulk of the discussion and treatment by the trial judge, Judge Dunn, focused understandably on the change in the parenting plan from mom having primary custody under the 2013 paternity judgment to a shared custody modified arrangement.
You're challenging the change in the legal custody.
I don't challenge that. I only challenge the legal custody.
So I thought that Macri versus Macri was a pretty important case, saying that a continued inability to communicate, where it becomes clear that that is contrary to the child's best interest, is a substantial change in circumstances that supports a change in custody. Why doesn't that rationale apply here?
Well,
they may have been failing to communicate all along, but it was
right.
becoming increasingly evident that this is contrary to the child's best interests.
Well, interestingly enough, the only issue that I think the evidence supported in the terms of a continuing problem, which had a material impact, was the issues pertaining to dental treatment, which occurred 5 years earlier. And at that time, there certainly were problems which resulted from how the child had been treated or the dental care. But since that time, there is really no evidence that the parties, despite the imperfect relationship that they have, the continued mistrust and so forth, despite that, there was no evidence that there was any material problem insofar as how they parented. It was imperfect, but it worked, but for that one occasion in 2018. Now, the judge focused on the events of, I believe it was September and October of 2021, when there were problems with the daughter-mother relationship, but that was addressed, obviously, in the parenting plan. So what the judge did find was, excuse my voice, it's a little squeaky. What the judge did find...
Get yourself some water if you want.
It's fine, thank you, Your Honor. What the judge did find was that the parties did share a commitment to this child, that they were able to capably care for the child, and that they were invested in the child. And so the question on appeal, in my perspective, is what was the change that would lead, thank you, counsel, what was the change that would lead to the taking my client's rights away in that respect?
Well, the judge also pointed to the father's key role in initiating the educational evaluation and therapy. Wasn't just the dental care.
Well, he called father the driving force in that decision-making, but the evidence showed that the mother was not, she was involved. I mean, she did play a role. They both looked for a therapist for the child when there were suicidal ideations. She was involved in arranging for or searching out educational testing to address the child's potential learning issues. So while the father may have been more proactive, the mother was involved. And again, before her rights were taken away in the manner that they were, I think the judge fell short in justifying it. I don't think the evidence supported it, and I don't think his findings or discussion justified it. You know, for example, the original judgment gave her the right to address religious doctrination. Well, that right is now gone, and that wasn't even discussed at all at the trial.
Is that a live issue?
Well,
I haven't seen it in the record.
Well, no, I'm speaking in generalities. You know, the legal custody rubric tends to address, you know, the larger issues: education, religious indoctrination, major medical issues, not
specifically about religious indoctrination. You ask us to apply a kind of a heightened standard based on the Kendall and the Sager cases. Those did involve the parents' fundamental free exercise right. And so some kind of heightened standard was discussed there. I'm not seeing how it applies here.
Well, it didn't apply, I mean, specifically. I mean, the legal custody right for religious indoctrination is a general right, which was initially given to the mother, and that was taken away. I mean, it was taken away implicitly. It wasn't specifically addressed.
I guess my question is, page 28 of your brief and onward make an argument that there were insufficient findings to justify subjugation of the mother's fundamental parental rights. Is a change in legal custody that doesn't involve a particular issue of the child's religious upbringing, is it subject to any greater scrutiny here than it is in any other legal custody case?
Well, I think legal custody has sort of two different components. One of are the more sort of fundamental rights of a parent, such as religious or education and so forth. And then there's the sort of day-to-day, you know, parenting issues.
Okay. There's a provision for consultation in the judgment on major issues.
Your Honor,
and I guess my question would be, was an argument made to the judge that special findings had to be made in order to justify a change in custody, such as you're making to us now?
No, I mean, the issues of education and religion weren't per se addressed, nor were they raised. I mean, the mother initially was given the right to direct the school through her residence. And at the present time, both parties live in the same town. So that issue was sort of You know,
Okay,
it
so
didn't need to be addressed.
Just so we're clear, the argument you're making, starting at page 28 of your brief about fundamental parental rights.
It would be a perspective, it would be a perspective issue if it came up.
Okay, but it wasn't raised to the judge.
No, there was not a dispute. The parties agreed to raise the child as a Buddhist. That didn't change, but it could change, in theory anyway, on a prospective basis, given the status change that the judgment imparted. And so, in this case, I think there were alternatives available to the judge on the legal custody issue, which were both embodied in the original judgment, where the trial judge in 2013 said, you know, the parties' relationship isn't so much the issue. I'm going to create provisions that allow both parties to have a continued role. When they came back to court in the 2020, the late 20s modification, which went to trial in 2023, there was a guardian ad litem who did an extensive investigation, which was really not addressed in any substantive way by the judge, and that guardian recommended other alternative approaches which would address sort of the fundamental communication issues and so forth, but still allow the parties to both have a meaningful say in this, such as going to therapy, you know, working on communication, taking a high conflict parenting course. Those sorts of things would be the reasonable alternatives that I would urge your honors to consider, as that the judge should have considered before taking this fundamental right away from my, excuse me, from my client.
Could you address the child support issue? And in particular, you've included a worksheet in your addendum that suggests that some support could be due from the father. The response to that in the father's brief, I'm sorry, that some support could be due to the mother. I apologize. The response to that is that, well, those income figures are not necessarily the applicable figures because of a one-time signing bonus, I think, for the father, and because of the mother's ongoing bonus, and that if you put those figures in, the mother actually has more income.
Wow.
So I'm leading up to my question: is the judge's finding that application of the guidelines would deal with a very small amount of payment from the mother to the father, is that clearly erroneous?
Could that be? Well, I think the problem here is that, in effect, the judge, by ordering no support, the judge effectively deviated from the presumptive application.
Okay, but if the application of the guidelines would lead to a small payment from the mother to the father, and the judge deviated downward from that, how's the mother prejudiced by that?
Well, she wouldn't be, but we don't know that because the judge didn't make the requisite findings under the guidelines in the statute, and that was really the gist of my argument.
So that may be an error, but was it a prejudicial error where it's not apparent that the judge's calculations were wrong?
It's hard for me to say either way. I don't know, you know.
Do you have a?
I admit that my I don't mean to interrupt you, Your Honor, but
go ahead.
My guideline worksheet was meant to be advisory. I don't know what the judge was thinking. The judge didn't tell us. This was my attempt to sort of understand or possibly identify.
But we don't want to send it back if we don't have to. If there was an error. If there was an error in not making findings, but
I'm not sure I would have appealed this case or taken the case if the child support was the sole issue, to be candid. But it is a concern, depending on what the judge found in terms of income levels, vis-a-vis a recurring bonus, a one-time bonus.
So this is on page 23 of the father's brief, that the mother's financial statement, the income figure that you plugged into your illustrative worksheet is actually lower because of her annual bonus. Now, lower than it should be because of her annual bonus. Now, the bonus fluctuated from year to year, but I guess in the most recent financial statement before trial, the bonus was $34,000, which could make quite a significant difference.
It
and
could.
and the father's income figure that was plugged into the worksheet was overstated in the sense that it included a one-time signing bonus of $13,500. So taking those figures into account, what would happen to your worksheet? Is it apparent that any money would have been due from the father?
Well, the treatment of the bonus could impact that number, and it could shift it to what the judge said, which was a small payment, from mom to dad. Her bonus, the treatment of bonuses in the guidelines it often bedevils the trial judges and is often treated differently. It's all because of the uncertain and contingent nature of bonuses. It's often not plugged in when a fixed amount is being ordered, because it will often then impart problems or prejudice in the future and lead to ongoing modifications. It's often treated on an if and when basis, on some sort of hybrid approach, like applying a 20% or something like that, and that would be how the bonus would be treated. So it could. I don't know what the impact would be if if opposing counsel's analysis bore fruit in terms of the numbers, but the larger issue is how the judge did not specifically address
Well, the judge
that.
plainly did a calculation, and there are guideline worksheets on the docket. So the finding is based on something. And, on appeal, it would be your burden to show that the judge made a clear error. So we can infer the judge didn't pull a number out of the air. It's based on the numbers that were presented to him. So how can we find clear error?
I think the error is the lack of findings in terms of not presumptively applying the guidelines or deviating from the guidelines.
No,
and not
the judge
explaining.
made a finding that he did the calculations.
But we don't know what the calculations are. Your Honor.
Okay, but he didn't pull it out of thin air, so he made a calculation and decided that the guidelines would result in a payment from the mother to the father, but he's going to deviate, which benefits your client, doesn't prejudice her. So unless we can say the calculation itself was clearly erroneous, what do we do?
I don't disagree with anything you're saying,
Okay.
Your Honor. It's just the unknown that I can't
But
address.
shouldn't we
It
see
also-
that, shouldn't we be able to at least see the worksheets that were presented to the judge?
But the judge, I mean, in terms of proposals? I mean, the judge did not provide.
What are these worksheets that appear on the docket, the trial court docket? There are, I'm looking at them right now. There are several guidelines worksheets on the docket. What are
Judge did
these?
not. I am unaware that the judge provided a guideline worksheet to come to the conclusion where he said there is a slight payment from mom to dad, which I'm waiving.
Are these guideline worksheets on the docket submitted by the parties, or are they the judge's worksheets?
I'm not aware the judge did that. They must have been submitted by the parties. I apologize for my ignorance, but I'm just being honest.
Okay. Thank you very much for your argument. We'll hear from the father. Father's counsel.
Good afternoon. May it please the court. Matthew Barak for Mr. Paul Chesler, the appellee. The lower court did not abuse its discretion by awarding the father sole legal custody of the party's minor child or not awarding child support to the party. This judgment is well grounded by both the testimony and evidence heard, and certainly within the broad discretion afforded to the lower court in matters related to children in the Commonwealth. As a result, we would ask that in all aspects this judgment should be affirmed. I will start with the point on legal custody. The lower court here made a detailed, thoughtful rationale in support of its judgment. The lower court made 101 specific findings. These findings include, related to the issue of legal custody, that the parties continue to lack an ability to work together in the best interest of their minor child. This was grounded in emails and texts showing a lack of trust between the parties and an inability to compromise in the best interest of their daughter. These findings were also confirmed by the guardian ad litem appointed by the court. GAL was concerned about the mother's behavior, calling it erratic, and found that at various times the mother had abandoned her child. And I'd point out that this happened on 3 different occasions, starting in 2017, 2020, and 2021. At one point, there was testimony, and the court found that she was told by her mother, the child, "I hope to see you someday, don't text me." At one point, mother told the father, "I'm selling my home and moving away," and informed the father of this child that dad could have full and sole custody. This behavior was found by the court and by the guardian ad litem to be confusing and akin to abuse and neglect of this child. She found that mom's behavior inhibited the parties' ability to make joint decisions. Not only that, mother was often unresponsive to the father or untimely in her responses to the child. And the court was troubled by mom's lack of candor, lack of responsibility regarding the child, and blaming the father for her own poor decision-making. Examples included, mother took months to reply to emails regarding enrollment related to school in Russian math. The school, an independent third party, also reported concerns about the mother's ability to communicate and act in the best interest of this child. As Justice Sachs points out, in the Macri case, our courts have held that continued and ongoing difficulty with co-parenting are grounds for sole legal custody. Joint legal custody is not appropriate where the relationship of the parties has been dysfunctional, non-existent, or one of continuous conflict. It's the Carr case. And in Mason v. Coleman, our court has held joint legal custody requires a willingness and ability to work together, which was clearly not here, presented by the evidence. And in the Joro Butu case, 95 Mass App Court 1107, if a prior judgment is not working to promote a child's best interest and is detrimental, those are grounds for modification. Likewise, in EKVSC, our courts have held them presented with evidence of a parent's interference into the needs of a child regarding educational or mental health services, an award of sole legal custody is in the best interest of the child. Here, the judge described the care of the child regarding her dental work as nothing short of disastrous. Now, I have to get scheduled for 3 surgeries up over here in the next 6 weeks, and I can't imagine a 6-year-old going through root canals and all the evidence that was presented regarding this poor kid's dental care because mom didn't believe it was necessary for this child to go to the dentist. But that's not it, and that's not all. There's also issues with a delay in reading and writing for this child that mom ignored. And the court found that it was the father who had stepped up and filled the void of the mother's lack of action regarding this child, regarding these major issues. And for all of those reasons, all confirmed by the GAL and the testimony, the court was well within its discretion below to award sole legal custody of this minor child to father. In re-custody of Zia, the court wrote, the decision of which parent should have sole legal custody is grounded by who will promote a child's best interest, and that is a subject within the broad discretion of the lower court. The evidence was clear here that it was the father who could promote the best interest of this child for these major decisions, and as a result, this judgment should be affirmed. Regarding the second point of child support, I'll say the following. One, this was a relatively minor issue in this case, as my brother alluded to. But I would point out that the lower court dealt with the issues of finances in 5 aspects of the judgment, that the lower court, as Justice Shin pointed out, had submissions of both financial statements and also child support guidelines that were submitted as part of the finding, as part of the submissions that...
Are they all party submissions? Because there are 4 of them.
My understanding is that, in recollection, although it's not within the record appendix, is that Those were submitted by trial counsel. I was
All,
not trial
all
counsel.
four of them?
For both parties submitted guidelines. Generally, what happens is at the end of a trial, when you submit submissions in the probate court, you submit the financial statements and child support guidelines.
I mean, normally, or at least in the decisions I've seen, you do see some calculations in the decision. So
Yes.
is this not a bit unusual that there are no calculations in the decision?
I don't find it that unusual because for the following reasons. One, I should say it's not necessary, but two, this was not, the child support piece was a minor component. The child support had been suspended in November of 2021. So by the time they got to trial, nobody's paying child support. So the financial piece, this case wouldn't have gone to trial.
But were the
with
worksheets
financial piece.
conflicting as to who would owe whom?
I think regardless, I didn't have it in front of me because it wasn't in the record, but our calculations as an example, if I use today, and I know this is for argument purposes, it's not part of the record, but when we ran the guidelines using both of their incomes, including his bonus, there was one-time signing bonus, as Justice Sachs pointed out, and mom's $34,000 bonus that she received in 2023. If you ran it with their highest incomes and the money he now pays or was paying for the health insurance, the guidelines would result today in a zero amount of payment. So what my point is that what this judge did below was he found that when he ran the guidelines, that it would be $50.
But you don't know if you don't know based on the worksheets that were submitted by the parties whether there was agreement as to who would owe whom?
No, I think it was minimal, but it wasn't, there's no evidence here, for example, there's no evidence that was submitted, or I believe testimony that's submitted regarding whether to exclude mom's bonus or not, or whether there was evidence submitted, I don't think there's any on the record to exclude dad's one-time bonus. But what I'm struck by is the word equal, and that's what the judge did in terms of deviation. He found that there would be a minimal amount of child support in his rationale. He found that the parties would continue to share equally the expenses and costs related to the child. He found that there was an equal parenting plan. And it is not unusual, and it's commonplace because child support certainly is modifiable, that when you have an equal parenting plan, an equal burden of the expenses related to a child, with parties that are essentially making almost the same thing in any calculation, that you end up with an amount that's zero. I think he was certainly within his discretion, and certainly on this record, there's no error of that, nor would it be worth the cost of that.
I saw that the responsibility for paying for the child's health care would change on January 1st of /24 from the mother to the father. How would that affect, if at all?
It would end up, if I run that with the $60 or so he was paying based on the guidelines that we had, and I run their income at the maximum both amounts, including the bonuses for both parties, zero. That would be the child support right now, based on that.
But can you just tell me as a general matter, where would an expense like this for the child fit into which box would it go in or contribute to on the worksheet?
Father's, because now he's paying the $60 because it's.
That's an expense or?
Yeah, so our worksheet.
The only worksheet that we have handed to us is the one in the mother's addendum at 111.
Correct. But what mother's addendum does not include is the bonus.
Understood. I'm not looking at the figures. I'm just wondering where does that go? Which box would we see?
If I put today the father's 60 and 60, it's box E and F.
Okay. All right. Thank you.
And so if you did the 3817, the 3750, we were just doing this for edification. It comes out as zero. So I think that the real issue here is that, whether or not the judge did enough, and I would submit he did. I think that he did look at it. He did have guideline worksheets in front of him. He did have 5 areas of the judgment in which he talked about the finances. And I think his conclusion is not in error whatsoever, and I think it's certainly within his discretion under these circumstances, because I think when you're when you have an equal parenting plan, when you're sharing the expense burden for taxes and expenses, activities, and the like, and your income is relatively equal, I think it kind of makes sense for, if it's such a minimal amount, to disentangle the parties, and that's actually in the best interest of this child. If there are no further questions, I will stand on our
Seeing none.
submissions.
All right, thank you. Thank you both for your arguments. I'd like to thank our court officers and our court staff, our law clerks, for their assistance with the session today. And with that, we are adjourned.
All rise, please.
I know.